Why am I doing no contest? Because he doesn't want to.
Liability.
Nah, no, I'm not doing that. I'm sorry. I,
It was mainly because of the explanation.
what do you mean the explanation? If he can't establish a factual basis, then we'll just set it for trial.
He can, but it's just for services. It wasn't what it actually is, if that makes sense.
And it doesn't make sense.
I know, Judge, but
What time is this at?
one was in the morning, one was at night.
Hang on. 10:05 p.m.
This courtroom session starts off anything but routine. A defendant refuses a no-contest plea, raising immediate red flags for the judge, and what follows is a cascade of cases involving late-night suspicious activity, intoxicated driving, drug possession, and emotional testimony that quickly spirals into legal complexity. From questionable plea strategies to strict judicial scrutiny, every moment in this courtroom carries real consequences. And just when things seem predictable, unexpected twists, from dismissed charges to intense sentencing decisions, keep everyone on edge. The real question is, who's taking responsibility and who's trying to avoid it? Let's break it all down.
For a reason, Judge.
Well, you're gonna have to tell me. I mean, if it's just a matter of somebody not wanting to admit that they're guilty, that really isn't an appropriate means to go about it. Is just doing it as a no contest plea. Hang on, if it's not, if the plea of no contest is because he can't make out a factual basis, that's not appropriate either.
That's not the reason, Judge. It's, I can't really say on the record, because I think it was my early attorney client privilege. But it was just for a specific reason.
Specific reason. That means somebody's going in looking through windows late at night. And stranger. I don't know what to tell you. I don't feel comfortable with a no contest plea. For the two reasons I mentioned, it's either there's no factual basis, or I'm not buying the possibility of civil litigation. You have two different dates, two different victims, it looks like.
I think the dates are the same, just two different times. I think both are March 31st, 2026.
You could be right about that. Yes, they are. Different times, different locations a little bit. I think they were both, let me just double check. Yeah. Look, I'm having a hard time with this no contest plea, Mr. Cayley. Your name? Your name?
Roger Taylor.
I'm having a hard time with that. I think I want us to regroup. I don't have time to do it right now. We got a lot of people. I'm gonna reschedule this, okay?
What's the charge then?
The window peeping.
Oh, okay.
You and I and Theo will sit down next time. We'll make it April 30th, okay?
Okay.
April 30th at what time, Heather?
10 o'clock.
10 o'clock. Okay, sir? You come back then and we'll see you back here. So go down the hall, get your new notice. Your trial date will be April the 30th. At 10 o'clock, okay?
Okay.
All right, good luck. Thank you.
Thank you, Judge.
Getting a little backed up here, so let me, Drew Gerald? Or Jarrell? Come on up here. Did you have a lawyer?
Yeah.
Okay, people against Drew. Aaron Jarrell Jr., 26B1502411A and B and C. Your name and counsel, your appearance.
Peter Granata, P78413, MIDC counsel for Mr. Jordan.
Good morning to you, Mr. Granata. So we've got an operating while intoxicated. We've got possession of a controlled substance, possession of a controlled substance, and an expired plate charge. So first of all, in the misdemeanors, does he in fact stand mute and waive formal reading of the citation?
Yes, Your Honor. Thank you.
All right, so I'm entering a not guilty plea for you for purposes of arraignment on the OWI and possession of a controlled substance. Now, as I understand it, there is going to be a plea of guilty to the charge of operating while visibly impaired, at which time the OWI will be dismissed, and he's going to plead guilty as charged under section 7411 to the possession of a controlled substance charge. True?
Yes, Your Honor.
He's never had one of those.
No,
He's never had a drug offense before.
no, Your Honor.
So, sir, if you plead guilty, did he sign an advice of rights form today?
It should be in the folder, Your Honor.
I see it. So let's start over. If you plead guilty to operating while impaired, I'll dismiss the OWI. With the further understanding that you plead guilty to possession of controlled substance under section 7411. Once you do that, I'm dismissing the OWI and expired plate. You understand that?
Yes.
Operating while impaired carries the possible penalties, the following possible penalties: up to $300 in fines, 93 days jail. Court costs are all those, 360 hours community service, 4 points on your license. Your license will be suspended or revoked in accordance with your record. You understand that?
Yes, Your Honor.
Possession of a controlled substance carries with it fines of up to 590 days jail. Costs are all of those, but I'll defer the proceeding. I'll take the plea, send you for a pre-sentence report, set terms and conditions. If you're compliant at the end of this period that I set, the case will be dismissed. Do you understand that? When you plead guilty to those two, I'm going to dismiss the OWI and expired plate. Do you understand that? Did you sign, read, and understand the advice of rights form?
Yes, Your Honor.
You plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, Your Honor.
The charge operating while visibly impaired, how do you plead?
Guilty.
To the charge possession of a controlled substance, how do you plead?
Guilty.
On March 15 and 26, were you operating a motor vehicle on Rochelle near Relda in Brownstown at 6:01 p.m.?
Yes.
Prior to that, did you drink alcohol? And if so, what did you drink and how much did you drink?
Yes, I had a few beers downtown for a parade. Probably 8 or 9 beers who I was there.
Was your ability to operate the motor vehicle impaired due to the consumption of the alcohol?
Yes.
How much did you have to drink?
It was a day-long event, so probably about 8 to 9.
And when you were pulled over, did you have a controlled substance in
Yeah.
possession, in your possession?
Yeah.
What did you have?
Okay.
And where was that located?
It was in my pocket.
And that was yours, correct?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
All right, I'm going to accept your guilty plea to operating while visibly impaired. I find it to be an accurate plea. I'm going to accept your plea of guilty to possession of a controlled substance. I'll take that under section 7411. Section 333.7411. So that means, again, I'm deferring that, and I'm going to go back and I'm going to dismiss on their motion the expired plate. So the OWI is dismissed, plate charge is dismissed, and again, please accept the operating while impaired, possession of a controlled substance. I'm referring you for a screening and assessment. You're going to fill out a questionnaire and be interviewed. Today, you'll come back for sentencing at a later time. Does he have any prior alcohol-related convictions, counsel?
No, Your Honor, not that I'm aware of.
Any prior convictions of any kind? Well, you got to resist and obstruct, drunk and disorderly. You got a felony armed robbery. Right?
Yeah, just 917.
Yeah, I know, but good. I want you going at AANA at least 3 times a week. So I'll give you a personal bond, $1,000, but here are your bond conditions. You cannot leave the state without the consent of the court or violate the law. You must appear in court as directed. No alcohol, marijuana, or illegal drugs. You're to submit to chemical testing, PBTs, and ETGs 1 time per week. We got to get you off the cocaine. You understand that?
Yes.
I'm ordering a screening and assessment. We're going to give you a sentence date And then you'll go down the hall, you'll get your date, and then your notice, your paper notice, and you'll go back and you will fill out a questionnaire and be interviewed, okay?
Okay.
I wish you well.
Your Honor, could we, set sentencing for, May seventh? That's the next day I'm getting.
Is that good? There was no accident here of any kind, right?
No.
Why were you pulled over by the police?
I was caught in a speed trap. I think I was going 31 into 25.
What do you want to do, Heather? I can do May 7th if you want.
That works, Judge.
May 7th at 8:30 in the morning, okay?
Thank you, Judge.
All right, thanks a lot. Good luck, sir. Go down the hall, get your notice. Yeah, you have to go to AA in person. My court officer's going to give you a form. Every time you go, you have to have the form signed. And you're also going to set up your testing with probation, okay? So AA 3 times a week, chemical testing once a week, go down the hall, get your court date back over to probation where you'll fill out the questionnaire and be interviewed and you'll talk to them about the testing, okay?
Okay.
Good luck.
Thank you, Judge.
Have a nice day.
Yeah, Mr. Cayley, come on in here. I need Mr. Khan in here.
Soon, Judge.
Yeah, I know. Caitlin Bianca Pat. 26F 245-254. Mr. Khan, your name?
Good morning, Judge. May it please the court, Sajid Khan, P65487 on behalf of Miss Pack, who's sitting to my right.
Sorry, I got to you so late here. My apologies. Mr.
Thank you.
Pack or Caitlin Pack, your name, ma'am?
Caitlin Bianca Pack.
So you're reducing this, I just need you to put on record, you don't think you have a case, right?
That's correct, Judge. The drug found in your system was sold off as not a controlled substance and it was under normal dose. However, it indicates on the bottle that it could cause drowsiness, which is what happened.
Was there an accident?
Yes, Judge, he was parked the car,
A parked car?
yes.
Okay, so, but I'm just, the only thing I'm asking is you're reducing this not because of anything other than the fact that you don't think you could prove your case,
I have
correct?
people doubt that's correct.
So we're going to take a plea to careless. Mr. Cayley says he can't prove his case. Is that what you want to do, Ms. Pack?
Yes,
To that charge of careless driving, responsible or not responsible?
responsible.
Well, your lawyer did a good job for you. I'm going to dismiss the original charge, 245. She can pay that today, Mr. Khan?
Can you get 245 today?
Yeah.
Yes, Judge.
I'll just make a note here. Proof problems, pay today. You're all set.
Thank
So-
you.
Thank you, Judge.
Sure.
There's stipulation by the defense that was probable cause for.
Yeah, I see that. And that's true, Mr. Khan. Your client stipulates it was probable cause to arrest.
Yes, for purpose of the plea, yes.
All right, good enough. Thank you.
Thank you, Judge. Thank you, Mr. Cayley.
Thank you. Brandon Brian Stoddard, 26R514453A. All right, Mr. Poodle, good morning. Your appearance?
Good morning, Your Honor. Julian Poot on behalf of Brandon Stoddard. Please state your name.
Brandon Stoddard.
All right, so your client pled back on April 2nd to operating while impaired. He was referred for a screening and assessment. Have you had the opportunity to review the report with him, and are there any material additions, corrections, or deletions?
No, Your Honor.
Anything you would like to say?
Your Honor, my client's 25 years old. He's got absolutely no prior criminal history. Worked as a production worker at Mama La Rosa Foods. He's quit drinking since the incident. He brought into my office here an 8-hour drug and alcohol certificate. He completed this class on his own. He's got his AA sheet here provided to me. Your Honor, as far as the recommendation, I'm asking if you would just consider tweaking a little bit instead of 8 months, if you would consider giving him 6 months probation and then give him credit for this 8-hour class he's already done for paragraph 6. And then he's asking if you would keep the work program hours to a minimum because he's working 50 plus hours a week at work.
I know, but he had a 0.205, which is scary. I can't do that, Mr. Puda. I'm sorry. I listen to anything else he has to say or you have to say. I'm not going to do that. I'm sorry. What do you have to say, sir? You had a 205, which is 2.5 times the legal limit, and you're awful young to be getting that high of a blood or breathalyzer result. So I'm just telling you, I'm not saying you're a bad person, but what else? Do you want to say anything?
This as far as when I was pulled over, it did come back a little lower. I know it's the rising blood alcohol content level, but it was lower when I was initially pulled over. I believe it was only a 0.13. Like I said, I do work a lot. That's all. I got work 50 to 55 hours a week right now.
He's a good guy, Your Honor. He's a nice guy here, and yeah, there was a discrepancy, Your Honor, with what he blew on the road versus what they ultimately came out at with the blood.
It still scares me when somebody this young has that high of a breathalyzer. All right. 12 months probation. You cannot leave the state without consent of the court. Excuse me. Or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you do have to notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any of those. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm in order that you attend the Victims Impact Panel, that you attend AA twice a week until you're in outpatient treatment. Once you get in outpatient, you no longer have to attend AA or NA. So twice a week until an outpatient, get in outpatient. When you start treating, you can stop going to AA. 4 days jail credit, 1 serve, 3. I'll let you serve those by way of the court work program. There's a $35 a day charge for that for a total of $105. 300 fines, $275 costs, 75 victims' rights, $50 justice assessment, 700 screening fees, 60 for 760. Probation fees are $240 for a total of $1,000 plus cost of recovery and court work program fees. I think my math's correct here. It should be $1,330. Heather, will you check that?
How much was the cost recovery, Judge?
$225. It was a blood draw.
Yes, I have $1,330.
So you pay that. I'll tell you what, I'll make the court costs instead of $275, I'll make them $200, bringing the total to $1,200 and $55. So if you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. For purposes of appeal, also, you may be eligible for early discharge. You get everything done in 6 months. By statute, you're entitled to discharge as long as there have been no violations within the preceding 90 days. Do you understand that, sir?
Yes, Your Honor.
Okay. Mr. Puda, can he pay all of this today?
Do you need time to pay or pay now? What could you put today?
Can I do 300 a day and I could have the rest next week?
I can give you additional time if you need it.
I could get it all by next week.
Your Honor, he could pay 300 today and he could pay the balance by next week. Yes.
I can give you more time if you need it.
I can give it to you.
No, I can pay it all next.
I'll tell you what, I'll just say 300 now and the balance is due by May the 5th. How's that? So you pay it anytime before May 5th. If you need more time, you call the court. We'll go on Zoom for the due date and I'll give you an extension. You have to come up here and meet with probation today, okay?
Yes, Your Honor.
Best of luck. Thanks, Mr. Puda. Have a good day.
Thank you, Your Honor.
gentlemen.
Nice to see you.
Emilio Alejandro Nino.
Yes, Your Honor.
Come on up here, sir. 26B149874. Your name?
Emilio Nino?
You're charged with larceny from a motor vehicle. You have the right to a lawyer. Do you want one?
Yes, please.
All right, we'll give you a lawyer.
Thank you.
You're gonna have to go right out and have a seat at the outside, and I will provide you a lawyer. Okay?
Which one is it?
Right outside in the. No. Just listen. Right outside the doors here from the courtroom. Just have a seat on those pews right out there in the lobby.
Okay, thank you, Your Honor.
Right when you get outside. Okay?
Okay, thank you.
You're welcome. All right. Mosgrove, Jalen Thomas Mosgrove, 25F518004.
Deon for DOB 8237A.
Sir, your name?
Jay Moscow.
How you doing, Mr. Montegrove?
Good, how are
We're setting one final pretrial?
Yeah.
When are we setting this for, what do you guys, oh, you're gonna subpoena the victim? Or he is? Good enough. April 30, Heather?
Yes, we can do this one at 9:45.
9:45. Okay, sir? You go down the hall, get your notice, and you're all set. All right?
Thank you.
Anything else?
No, thanks.
Thank
I
you.
do- Yeah, I do have some more.
Okay, no problem. Nathan, no, you're all set. Nathan Lee White, the 20R 511, 848. A and B, 21F 236324. A and B. Mr. White, your name?
Nathan White.
Dion Patillo, P82378 on behalf of this, the name of the.
I didn't hear a word you said there, sir. You got to keep your voice up.
Nathan White, sir.
Can you get closer to the device or turn the volume up on the device a little bit, please?
Yes, sir. Can you hear me now?
I can. All right. So Ms. Patillo, he's in Dallas.
Yes, Your Honor.
He's going to plead the no ops.
Yes, Your Honor.
They're going to dismiss the suspend. True?
Yes.
Is that what you want to do, Mr. White?
Yes, sir.
If you plead the no ops, possible penalties are up to 100 fines, 90 days jail, costs are all those. And I will point out that you have other tickets here that you're in default on, and I'm going to expect you to pay those. Do you understand that?
Yes, sir.
All right, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the constitutional right to a jury trial. At that trial, you have the right to remain silent. You have the right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're going to be giving up all of those rights, and we're not going to have a hearing or a trial of any kind. Do you understand that, sir?
Yes, sir.
All right, you understand all your rights.
Yes, sir.
Understand you plead guilty. We're not going to have a trial. You're giving up your right to remain silent. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt.
Yes, sir.
To the charge, no valid absent person, how do you plead?
Guilty, sir.
On August 12 of 21, were you operating a motor vehicle on Telegraph and Moses in Flat Rock at 9:23 p.m.?
Yes, sir.
Did you have a valid license with you on your person?
Yes, sir. I thought I did. No, I guess I didn't.
Hang on. Did you have a valid license on your person?
I had a Florida driver's license.
But you didn't have a valid Michigan operator's license, correct?
No, sir. No, sir.
Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No, sir.
That plea is accepted. The suspense dismissed. He owes $362 on 2OR 511-848B. He owes $362 on 21F236324B. He owes $338 on 2OR 511-848A. You have all that to pay. 362 plus 362 equals 724 plus 338 equals $1,062. Do you have all that to pay?
No, sir. I'm currently unemployed looking for work. I've got 2 interviews. I had 2 interviews yesterday. I got an interview today and tomorrow. I'm currently in a transitional house in Dallas, Texas, and I just entered the phase where I can get employment and start taking care of these past transgressions and getting my life back together.
What do you have to say?
But it sounds like he's been doing really good. Specifically, he said that he found Jesus about 3 years ago, so he's been trying to do a lot better. As he stated, he had those 3 job interviews, 2 already. He's waiting on 1. He also graduated from Dallas College on April 8th, 2026. Now, because he's looking for work, because he's doing so good, I know that those late fees probably push those tickets up a little higher. I would ask if the court would be willing to waive some of those late fees.
It would if he had some money, but he'd been outstanding for 4 or 5 years, though.
Right, but the reason that he hasn't been here, he was in prison for 5 years. He wasn't released until December.
What was he in prison for?
He said it was drug related. So he is doing better. I think that if some of those late fees are waived, it would bring it down, and then he could comply with the payment from him once he finds work. Your Honor.
You guys drive a hard bargain.
I have every intention of paying, Your Honor.
$100 fines on this no. Do you want to say anything else on the no ops?
No.
Sir, anything?
No, sir.
100 fines, 70 costs, 75 victims' rights, $50 justice assessment, $295 or 60 days. When, I'm trying to figure out how I want to do this. I'm not gonna waive late fees or any fees if you aren't prepared to pay something today, and I get it, but you don't have the money, but these tickets are 5, 6 years old.
Yes, sir.
I'll tell you what I'll do. On the no ops. I'm gonna give you, I want you to write this down. Will you write this down for me? That's $295. You're to pay that by July 1. On the case, the no insurance 20R 511848B. You pay that by August the 31st. That's $362. On 21F 236324B, you owe $362, pay by October 31st. I don't think you're gonna pay these. I hope you do. If you don't, well, we're gonna have a problem, but you're gonna be in suspension for the rest of your life. On 20R 511848A, pay that by December 15th. Now, if you need more time on any of these, Mr. White, you just call the court. I'll be glad to give you an extension, and we'll go from there, okay?
Yes, sir. How much was that last one on December 15th?
338.
338.
If you want to, if you have the money on one of these and you want to call the court and say, hey, I'll consider reducing fines, Heather. So I don't know how you want to put it in the computer, but if you call the staff, 671, this is our phone number, 734-671-0201.
671-0201.
Extension 228 it is, right, Heather, or 4?
Yes.
228. You call her, and I'll just make a note. Heather, will you make a note in the report and on the rep file that if he comes up with the money and he has it, I will strongly consider reducing some of the fines, at least on the 3 civil infractions, okay?
Okay, Judge.
But you'd have to call us. Good luck.
Thank you, sir.
Thank you, Judge.
Thank you. Tariq Anthony Kuczynski. Where's he at?
I didn't tell him to come in, Judge. I'm sorry. Deon Patillo, 8237, on behalf of Mr. Kuczynski.
Name?
Tarek Kaczynski.
Victim was subpoenaed, failed to appear. Prosecutor subpoenaed her, says people unable to proceed. He moves to Nolly Pros. Case dismissed. Heather, take all those bond conditions out, will you please?
Yes.
All right, so you're all set, and there's a bond to be returned. You go down the hall and talk to them. Actually, it's in the name of Amanda McNeil, so she should contact them, okay?
Thank you.
Really with you?
Thank you.
Is she with you?
Yeah, yes, sir.
So she can go down the hall.
Yes.
Good luck.
Thank you.
Yoletta Thompson, 26F264290.
Deon Patillo, P 82378, on behalf of Ms. Thompson. Billington Thompson.
Your name?
Billington Thompson.
Okay. Victim subpoenaed, also failed to appear. So prosecutor's moving to Nolly Pros. Case dismissed. You're all set, ma'am. This was a personal bond. We're gonna make sure we take the bond conditions out of that too, Heather. Thank you. Good luck, ma'am. You're all set. People against, do 4. Counsel, your appearance.
Good morning, Judge. Madison Gave up here on behalf of
He stands mute, waives formal rating, does he?
Yes, sir.
What kind of drug was this allegedly? I'm gonna enter an act guilty plea. Cocaine possession is the allegation. Sir, I'm gonna give you $1,000 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. Do you understand all of that? $1,000 personal bond. I don't believe he was ever printed on this case, so I'm gonna order him to go over and get printed. You weren't fingerprinted at Brownstown on this case, were you?
No, Your Honor.
All right, so $1,000 personal bond. You have to go over to the Brownstown Police. First of all, let me tell you all the terms here, okay? You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You have to go there and get photographed and printed at the Brownstown Police Department by 1 p.m. today. You have to attend AANA at least twice a week, AANA twice a week. And you have to go in person, okay, twice a week. And every time you come to court, you have to bring that form with you. And every time that you go to probation, if it gets that far, if you're ultimately convicted, you have to continue. And I order you to continue going to AA. You have to bring that form to evidence the fact that you attended. Again, that has to be in person, okay? In person. So no alcohol, no marijuana, no illegal drugs. You cannot leave the state. You cannot violate a law. You must appear in court as directed. Those are all your bond conditions. You can go ahead, go down the hall. We've given you the AA form twice a week. We'll send the order over to Brownstown for the order for prints, and we're going to give you a court date. Yeah, stay away from that. No alcohol, marijuana, or illegal drugs. What are we doing, the 30th here, Heather?
No, this is a Brownstown case, Judge, so it'll be May 6th at 8:45.
6th at 8:45 will be the court date. Okay, that's a Brownstown case. If you want a petition for a court-appointed lawyer, if you want a court-appointed lawyer going forward, you're going to have to fill out a petition for one, okay? I mean, you're entitled to one at the first hearing, but after that, you have to be indigent. All right? Good luck to you. Any questions, sir? Sir, do you have any questions?
No, sorry.
Okay, that's all right. Orterius Brandon Johnson, 26B-150-198 A, B, and C.
Good morning, Judge Madden gave the turn out Mr. Johnson, Mr. Johnson, state filmmaking.
All right, so what do we do on this one?
Judge, we're asking for an additional adjournment here.
No problem.
We have, conditions,
Okay, this is Brownstown, Heather. What do we want to do on this?
May 6th at 8:45.
So May 6th at 8:45, okay, sir?
Sir.
And let me just check something. Did I not set bond conditions when he was here before?
I don't recall that.
You have any bond conditions in there, Heather?
I do not.
CB. Okay. Let's check something. So you cannot leave the state without the consent of the court. You cannot violate a law or ordinance. You must appear in court as directed. I don't know what kind of controlled substance this was allegedly, but I'll let it go with that. So you go down the hall, get your court date, and we'll see you back here. Where do you work at, sir?
I work for recycling and nonprofit and
How much do you make there?
make $30 an hour.
Yeah, I can't appoint you a lawyer. I don't know how this got through here. You're gonna have to fill out a petition for one if you want one. I doubt I'm gonna appoint you one if you're making it.
I did a lawyer because I am the mother-in-law child stable, and I take care of both of my kids.
You're still gonna have to fill out a petition.
Did fill out one, but that's the most for one.
Did I give him a court-appointed lawyer?
You'll see.
Oh, yes, I did. You're right. I did give you one. My mistake. Sorry about that. You're all set. Go down, get your notice, and we'll see you back here on the 6th. Good luck. Alexis Rachel Seiler. Alexis Rachel Leanne Seiler, 26B-150-604.
Good morning, Judge Madden gave the turn out still saying his name.
Alexis Rachel
So she's going to plead to no ops, but first of all, she's standing mute for purposes of arraignment and waiving formal reading. Is that correct?
Yes.
She pleads to no ops, ma'am, and that's what this says. The suspend will be dismissed. Possible penalties are up to 100 fines, 90 days jail. Costs are all those. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? To the charge, no valid operator's license on person. How do you plead? Were you operating a motor vehicle in the township of Brownstown on March 29 to 26, at or near 17961 Inkster in Brownstown?
Yes,
Did you have a valid license with you on your person at the time?
No,
Are you on probation or parole?
no,
Anybody force you to plead guilty?
no.
Plea is accepted, suspends, dismissed. Why am I seeing her so much? She was in here yesterday.
She has another matter for you, Judge.
I know, drunk driving. That's worse.
But I was driving.
Okay. Don't talk about it. Don't talk about it. What do you want to say? You talk to your lawyer about it, okay? You talk to your lawyer about that, not me.
Judge, just that Ms. Siler is in the process of working to get her license reinstated. Obviously, she understands that she can't be driving without a license and that she needs to make arrangements to correct that. If she is, isn't that correct?
It is.
Anything else, Dan, you want to say? 100 fines, 70 costs, 75 victims' rights, $50 justice assessment, $295 or 60 days jail. $295 or 60 days. Do you have the money?
Can I pull up my phone to see what I have in my bank right now?
Sure.
I can pay 2 today and then I can do the rest Tuesday.
Fine, $200 today. I'll give you till the 23rd to pay the rest. If you need more time, you call the court. We'll go on Zoom. I'll be glad to give you an extension, okay? Good luck. Robinette? Ryan Hunter, Robinette, 26B15171.
Good morning, Judge. Nice and good. Mr. Robin.
So. How you doing, Mr. Robinette?
No, actually, over here.
Your name?
Ryan Hunter, Robinette.
So you guys are stipulating to a competency exam?
Yes.
Yes, I do.
Okay. So we're gonna have to adjourn this. So you're gonna prepare that order. We're gonna prepare a competency, order for competency exam, which we'll send out. I don't know what to tell you here. I don't know how long it's taken now, but I'm assuming, so it stayed anyway, the timelines. So I'm gonna say, let's go out 6 weeks, Heather, see if we got it back then.
Judge, for the competencies, they're usually going on 90 days.
Yeah, I know, but that far now?
It depends on the forensic.
Well, let's try 8 weeks. How about that?
You are not here in 8 weeks. That puts us to June 11th. We do have a visiting judge here that day.
Yeah. Who is it? Is that judge going to handle my docket or part
I
of my
believe
docket?
I believe we have Judge Kirsten that day.
Let's do June 11th at 8:30 in the morning. Okay, sir?
Yes, sir.
All right. I wish you well. Best of luck. Go down the hall, get your notice, and you're all set. Okay?
Thanks.
Best of luck to you. Raven Lee Osborne III. Raven Lee Osborne III. 215-234-345. Mr. Osborne, your name?
Raven Lee Osborne III.
Mr. Carmen?
Michael A. Carmen, please have a brief before, and I'm standing in for a record.
All right, so he's going to plead to possession of drug paraphernalia, the controlled substance to be dismissed. Prosecutor has no objection to time served, right? If you plead to that, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, Your Honor.
Presumed innocent, they have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own. If you plead guilty, you're giving up the presumption of innocence and you're waiving those requirements. Do you understand that?
Yes, Your Honor.
To the charge possession of drug paraphernalia, how do you plead?
Guilty, Your Honor.
On February 12 of 21, were you on Freeland or Telegraph in Flat Rock at 12:24 in the morning, and were you in possession of drug paraphernalia?
Yes, Your Honor.
What did you have?
I had a pill bottle, empty pill bottle.
And that was, what was in the pill bottle?
There was a napkin, I believe, stuffed in it. That's all that was in it, I believe. I never opened it. I had got it from a child, so it was just an empty pill bottle with napkin stuff in it.
Wait a minute, slow down. What was the drug paraphernalia, sir?
I'm unaware of what the prescription was.
This was not medication you'd received from a doctor, right?
No, sir. It was just a pill bottle.
For me.
Yeah, your name?
Yeah, the city of Flat Rock, Judge, was Flexerol.
Okay, that he had,
Yes,
was it prescribed
it
medication?
was.
Well, if he's got,
Not to him.
I see. Is that true, sir? It was not prescribed to you, right?
Correct.
Anybody force you to plead guilty?
No, Your Honor.
Please accept it. I can make this quick. He's been in since March 20, right? Is that right?
Yes, Your Honor.
All right, I'm just gonna, unless somebody wants something to say, I'm gonna just give him 20 days jail, credit 20.
No, Your Honor, that would be perfectly acceptable.
You good with that, sir?
Correct.
Yes, Your Honor.
No fines, no costs. 20 days jail, credit 20. And you're all set. Good luck.
Thank you, Your Honor. You have a good day, everybody.
You too. Leah Marie Kirk.
Yeah.
267-245-713, A and B.
Mike Conley, 73884, standing in for attorney record Dion Patillo.
And does she stand mute? She stand mute, wait formal reading?
Yes, sir.
Your name, ma'am?
Leah Kirk.
All right, so now there's going to be a dismissal of the disorderly if she pleads to R&O under section 771.1 for a period of 6 to 12 months, and there's a lack of memory on this. Was there alcohol or drugs involved? Can you tell me? Yes? Is that
Yes.
right?
Your Honor, yes.
All right.
Memory.
So, ma'am, I'll take your no contest plea to that.
Okay.
If you plead no contest due to a lack of memory,
Okay.
that has the same effect as a guilty plea. Here's the report. The possible penalties are up to 500 fines, 90 days jail, costs, or all those. Again, a no contest plea has the same effect as a guilty plea. If you plead no contest, you're giving up all the rights that I talked about or that you have here. You have trial rights. You have the right to a trial by court or jury. You have the right to remain silent. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
I understand.
All right. And you stipulate I can use the police report to establish a factual basis? To the charge, resist and obstruct an officer, ma'am, how do you plead?
No contest.
All right, I'm going to review the report. All right. Based on my review of the report, I find there's a factual basis for the plea. Are you on probation or parole?
No.
Anybody force you to plead no contest?
No.
All right. I'm going to accept that plea, dismiss the disorderly. I'm not going to. Does she have priors? She have priors.
No.
I'm just going to go ahead and set a sentencing date. This is a lengthy report. I'm going to set a sentencing date. I'm not ordering a pre-sentence report. I'll let you zoom in again. You're still in Lansing, right?
I am.
We'll make it April 30. Is that good?
Yes, Judge.
At 8:40. What time should I make this? Yeah, 8:45 is good.
No, we can't do that. You'll be at Quarter School.
Oh, okay. What
We
time?
have to do it. We can do 10:45.
10:45. Okay.
What is this?
10:45 in the morning. I got to clerk the school
April
program.
30th.
All right. So I'll see you April 30 at 10:45. I'll read the report and I'll sentence you at that time. Anything else, Mr. Carmen?
No, sir, Your Honor.
Ma'am, I'm going to give you $1,000 personal bond, but no alcohol, no controlled substances. Do you understand that?
I understand.
No alcohol, no marijuana or illegal controlled substances, 1,000 personal. We'll see you here then. Anything else?
Sir.
Thank you very much. Thanks.
Your Honor.
Do I have anything else ready out there? Did you meet with the lawyer?
Yes, sir. Yes, Your Honor.
Who's your lawyer?
That's his name, Your Honor.
It might be bad. I'm not sure who this other one that came in on county. They logged back in with another.
Sir, what's
one.
your name?
What's your last name?
Yeah, you.
Enoch, and I know.
Oh, he's muted there.
Donald Kowalski?
See, on the docket. What's that for?
Oh, he was also a 10:45. Sorry, Judge. He was also a 10:45.
What case is this? What city is this case out of?
Case.
Trenton. That was
Is this
that one. That was that one that Bologna gave you, I believe.
Oh, no. He thought he was out here.
No, and I know.
Do you have
Do you
that
want me to call
file?
him and see if I can have him zoom in?
Yeah. Let me see the file first. Kowalski. He brought it in. He said he had a no-show.
I talked to my attorney yesterday, McNally, Judge McNally.
Let me get the file first.
Yes, sir.
Mr. Gates, you don't have Kowalski, do you?
No. See if he's still here, Joe.
We had
Yeah,
Patillo on
please.
that last time.
Please. You know, I'd feel sorry for you if you. Well, wait a minute. You posted your bond. You didn't post. Hey, he didn't post a bond. Are you in custody on this case only, Mr. Kowalski?
No, I seen you last Wednesday and you sentenced me to 30 days on one, and then I have another court date for today for the same charge, but at a different, but for different. I talked to my attorney last night. She came and seen me on a video arraignment. Her name started with a P.
Miss Patillo.
Yes.
She's gone.
I can do that, Your Honor.
Yeah, I want to go to. But Trenton's not here.
I can call Mr. Bologna.
You know what? I know. So we got a problem. Well, go ahead, try it. See what you can do for me, okay? We'll take that one. But here's the thing. I don't know why we didn't know, why we're not. Do you? How did he not know he was in custody? I guess is my question.
You sentenced me to 30 days already, so I'm already here for the case from last one.
I'm not talking to you, sir. I'm talking to my judicial clerk.
No, I've heard that was mine. That got by me, Judge.
Okay, let me go on here, and they're going to see if they can get a hold of Mr. Bologna. Emilio Alejandro Nino, 26B149-874.
Good morning, Judge. Well, good morning, Judge. Madam Gate, on behalf of Ms. Nino, Mr. Nino.
Your name, sir?
Full name?
Emilio Alejandro Nino.
For the purpose of judge, can you waive reading?
Larceny from an automobile. Okay, so I'm gonna go ahead and enter a not guilty plea. Because that's what you want to do is have him stand mute, waive formal reading, and then set it up for another pretrial, correct?
Correct.
So that's what I will do. Where do you live now? You live in Ecorse, Mr. Nino?
Yes, Your Honor.
At this address on it looks like Glenwood?
Yes, Your Honor.
All right, so I'm gonna give you a bond here. I'm gonna continue your bond. No alcohol. Wait a minute. No contact with the victim. You're not to enter or go near 23163 Brentwood Drive in Brownstown, so you cannot go near there. Do you understand that?
Yes, Your Honor.
Also, you have to go to get fingerprinted and photographed at the Brownstown Police Department by 1 p.m. today.
Yes,
Okay?
Your Honor.
So you have to go over there today, get fingerprinted and photographed by 1 p.m. I'll fill out that paperwork. We're going to give it to you. So I'm going to cover this a little bit better with you. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I'm not going to say no alcohol. I have no basis to believe that that's involved. So that's not a condition. No contact with prosecution witnesses. You're not to enter 23163 or go near 23163 Brentwood Drive in Brownstown Township. And you have to go over and get fingerprinted and photographed at the Brownstown Police Department by 1 p.m. today. Do you understand that?
Yes, Your Honor.
Okay. So go down the hall, get your notice. We're going to give you a court date here momentarily. Go down, get that, and take your bond sheet, and then go over to Brownstown. What do you have for me, Heather? Is it the 6th?
Yes, that'll be May 6th at 9:45.
9:45. If you want a court-appointed lawyer going forward, you're going to have to fill out a petition for one, okay?
Okay.
Best of luck.
Thank you, Your Honor.
You want court to come to the next one?
Yes.
Let's see you in here.
Bradley Lawrence Guyot. 26B150513A and B. All right, what do we got here? We got an operating while intoxicated, and we got an open intox. Counsel, your appearance.
Good morning, Your Honor. Peter Granada, P78413, and I'm DC counsel for Mr. Guy.
Sir, your name? All right, so we have those two misdemeanors. Does he stand mute and waive formal reading?
Yes, sir.
And now you pre-tried it. So I'm entering a not guilty plea for you on the open intox, sir, as well as on the OWI. But now you've met with the prosecutor, Mr. Granado. Is it true that he's going to plead guilty to operating while impaired?
Yes, sir.
And that he's also going to plead responsible to distracted driving, and the prosecutor is going to be dismissing the open intox. Is that true?
Yes, sir.
So do you understand, if you plead to operating while impaired and you plead to distracted driving, which is a real break on the open intox, that I'm going to dismiss the open intox, I'm going to dismiss the OWI, and you'll come back for sentencing at a later time. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
If you plead to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all those 4 points, license suspension or revocation in accordance with your record, and your vehicle could be, or might have to be immobilized depending upon your record. Do you understand that?
Yes.
And if you pleaded distracted, that's a 0-point violation. That's a civil infraction only. Do you understand that?
Yes.
And is that still how you wish to proceed?
Yes.
And you understand all your rights?
Yes.
To the charge operating while visibly impaired, how do you wish to plead? Were you operating a motor vehicle on I-75 near Gibraltar in Brownstown, March 20 of 26 at 11:38 p.m.?
Yes.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes. Don't recall how many. I had a
What were you drinking?
couple seltzers and a couple beers.
And was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
So
That's okay. Was your ability to operate the motor vehicle impaired due to the consumption of the alcohol?
yes,
Why were you pulled over by the police?
I lost control of my road entry.
Okay, you think you did that at least in part because of your alcohol consumption?
Yes.
Did you take a breathalyzer or a blood test? And counsel, do you stipulate that the result of the breathalyzer was 0.113 and that
Yes,
it's
sir.
accurate for purposes of the plea?
That is accurate.
Right now, are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
To the charge distracted driving, you plead responsible or not responsible? I'll accept your plea of responsibility to distracted driving. More importantly, I'll accept your plea to the charge of operating while impaired. I find the plea has been made voluntarily and understandingly and is an accurate plea. That plea is accepted. The OWI is dismissed. The open intox is dismissed and refer you for screening and assessment. You'll be screened and assessed today, sentenced at a later time. Like I said, $1,000 personal bond, $1,000 personal bond, and no alcohol, no marijuana, no illegal drugs. Okay? And you're going to go down the hall. You're going to get your court date.
Your Honor, could we ask for May 7th, which is my next time as House Counsel?
Yeah, is that good? Well,
Yes, we scheduled that other one for Mr. Granado that day also.
Yes, thank you.
what did he drive into?
Tree.
Was it on somebody's property?
No, I was on the off ramp, off the off ramp.
We'll set it for May 7th
Thank you.
at 8:30.
Yes, sir.
At 8:30. Okay. All right. And you're all set. I'm also setting the distracted for that same date, Heather. Okay, so we'll just sentence them both. I'm going to defer sentencing on that one until then. Okay?
Thank you.
Thanks. You're all set. Go down the hall, get your notice, and then go over to probation right across the hall. You'll fill out a questionnaire and be interviewed. Okay?
Thank you.
Thank you. Wow, they're just not quitting today, are they? Natalie Nicole Brown. 26F245-755 A and B. We have two charges here. We have a destruction of property and we have an entering without permission. Counselor, your appearance.
Maria Peter Granada, P78413, and my DC counsel for Ms. Rose.
Ma'am, your name?
Natalie.
So for purposes of arraignment on these, she stands mute?
I will stand mute, ask for it or not.
I will do so. And now, as I understand it, she is going to plead guilty to malicious destruction of property. And the prosecutor then is going to move to dismiss the entering without permission. True?
Yes, sir.
Is that what you want to do, ma'am?
Yes, sir.
If you plead to that under local ordinance, destruction of property, that's punishable by up to $500 fines, 90 days jail, costs or all those. And I would take that plea. We'll set it for sentence. The victim may show up and ask for restitution. Do you understand that? I will take it under that provision of 771.1, place you on probation, set terms and conditions, and if you're compliant at the end of this period that I set, 6 to 12 months, in my discretion, then the prosecutor will move to dismiss. Do you understand that?
Yes, sir.
Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? All right, to the charge malicious destruction of property, nice and loud for me. How do you plead?
Guilty.
On March 29 and 26 at 4:01 in the morning, were you at 25811 Valley Creek Drive, apartment 1106 in the city of Flat Rock?
Yes, sir.
And what did you do?
My entered the operation and
I don't want to know about that. I want to know, did you destroy something?
yes,
What did you destroy?
closet.
Okay, listen. Okay, tell me whose closet, why you did.
His closet door. That's what he's saying. I broke his closet door.
Did you break his closet door? What do you mean you could have? Did you hit it, kick it, breathe on it? What did you do? Come on.
It's in the report, but I can't remember breaking the closet.
Your Honor, it's like the heat of the moment there.
I
She
know.
doesn't really recall.
Was she drunk? Were you drunk?
I'm sober.
Okay, this was only 17 days ago, 18 days ago. So tell me what you did.
I broke the closet door.
Okay, let's slow down. Who's this gentleman that you referred to?
Solomon Knight.
The complaint.
Solomon Knight. And were you going out with him?
When I came home that night, I came home to Uber and he was outside my house and he like flashed his lights to get my attention. And we had agreed I was gonna come down there, but at the last minute he flipped the script. And that is when the destruction of his property happened.
Whose house were you at?
I put up to my own home.
Right.
He was outside my house. He flashed his lights to get my attention. And I went to his car. We had a conversation that I would come down to his house.
How far does he live from you?
Literally a couple of apartments down.
Okay, so then what happened?
So I went in the house to change my clothes and I told him I would be down there, but he flipped the script at the last minute and told me he didn't want me to come. But that's when everything occurred after.
Okay, so did you still go down to his house?
After I went home.
Did you walk in without permission?
Yes.
And then what did you do?
I broke the closet door.
And how did you break the closet door? Did you kick it, punch it, hit it with it? What'd you do? Come on.
I guess in the tussle.
I don't want you to guess.
He was kind of being aggressive with me and I guess in that moment, that's when it got broke.
You got to be more specific with it.
Me and him were arguing
Okay.
and it got a little physical. And he was kind of swinging me around the apartment.
He was swinging you around?
Yes.
Is that what caused the door to break?
Yes,
Then
that's
how
what
can
I'm
I take this plea? If you didn't intentionally strike and cause damage to his closet door, I can't take this plea, man. And it's okay. We can just set it for trial. I'll be glad to do that.
Your Honor, there were a couple different issues. First was the closet door, but there was also damage done to the screen and the threshold when she entered.
That's what I thought it was gonna be about the screen, but
They
he's
didn't,
talking about.
it's not in the ticket, but it actually is in the report that there was damage done to the threshold and window.
Well,
The screen wasn't even broken itself. I slipped the screen out.
let's just slow down. Let me read this. Breaking the residential window threshold. I don't know what they mean by that. Did you,
Removing the screen from the window.
I mean,
did you damage it in the process of doing that? All right, then let's talk about the closet door. Did you intentionally strike the closet door?
Yes. Yes.
Well, don't tell me yes because you think I want to hear yes. I want to hear the truth. Did you intentionally damage that door?
No.
Well, then let's not. I can't. I don't know what to tell you. I can't take the plea to MDOP. They're talking about intentionally damaging the door. If she didn't intentionally damage the door. So I'm not going to take the plea. We're going to have to reschedule it. If it doesn't resolve then, I will simply set it for trial. So here's your bond conditions. You cannot leave the state without the consent of the court. You cannot violate any law. They must appear in court as directed. No contact with the victim, Solomon Knighton. You can write, phone, see, text, email, or communicate with him in any way. And you're not to enter the property address or go near 25811 Valley Creek Drive, apartment 1106. Do you understand that in Flat Rock?
Yes.
All right, so I'll have you fill out a petition. No contact with him or prosecution witnesses except through your lawyer. You can fill out a petition for a court-appointed lawyer. Those are your bond conditions. And we'll give you another date. You can come back. You can think about it. You can do whatever you need to do. If you want a trial, we're going to give you a trial. You know what I'm saying? That's not a problem. Shouldn't be pleading guilty to anything you didn't do. Let me see what I have here, Heather. I got to double check one thing first. You did get printed on this. Okay, good enough. So that's it. You can give me a court date, Heather, and we'll go from there.
April 30th at 10:45.
April 30th at 10:20, at 10, what'd you say, at 10:25?
45.
Sorry. Okay. Good enough. That's it. You're all set. Thank you. If you want a petition for a court-appointed lawyer, if you want one, you're gonna have to fill out a petition for one going forward now at this point, okay? Good luck. He's gonna get, it's right there behind you. He's gonna have you fill that out. All right. Nicholas Alajon Chandler. 26B150526A. Mr. Chandler, your name?
What's the line? Chamberlain?
Counsel?
Your Honor, Peter Bernard, P78413, and my DC counsel for Mr. Chamberlain.
All right, so this is going to be a plea. I already arraigned him. At the conclusion of that, he told me he did not want initially he said he didn't want a lawyer. Then he said he did. So I appointed you. He's going to plead guilty to allowing a licensed driver to drive, and they are going to dismiss the suspend, and he's also going to plead the speeding 1 to 5 over. True?
Yes, sir.
That, sir, speeding charge is a 1-point violation. It's a civil infraction. If you plead to that, that will go on your record. If you plead on allowing a licensed driver to drive, that will not go on your record. That is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand me? And again, did you sign, read, and understand an advice or rights form here today? Pardon?
Yes,
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that? To the charge of allowing an unlicensed driver to drive, how do you plead? Were you in control of a motor vehicle being operated in Brownstown, a 2022 Buick on Inkster near Claret in Brownstown, March 29 to 26 at 1:43 in the morning? Or, I'm sorry, 1:43 in the afternoon.
Sure.
And did you, you were unlicensed at the time, correct?
Yeah.
Either had a suspended, revoked, or denied license, correct?
Yes, sir.
And knowing that, you still operated the vehicle, correct? Are you on probation or parole?
Yes. No. No.
Anybody force you to plead guilty?
No.
Please accept it. And I'll also ask you to 1 to 5 over, how do you plead responsible or not responsible?
Okay. Responsible.
All right, I'll accept that plea. So I'm going to sentence on both. I'm dismissing the suspend, accepting the plea to 1 to 5 over, and to allow an unlicensed driver to drive. Anything he wants to say?
No, Your Honor, we're ready to go to immediate sentence.
Anything you'd like to say?
Your Honor.
100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4 or 60 days on allowing an unlicensed driver to drive, 150 on the speeding. You owe 475. Can you pay all of that today?
No.
How much do you have today?
100.
You pay 100 now. That'll be on the speeding. Where do you work? How much do you make?
Anywhere from $400 to $600 a week.
Can you pay this by April 30th? The remaining $50.
No.
And then on the other case, I'll let you pay 40 per week starting April or May the 6th. Is that good?
Yes, Your Honor.
That's what we'll do. So you pay 100 today on the speeding. You pay the rest of that, which is 50 more by April 30. Then starting on I'll just make it May the 7th. You pay 40 per week beginning on that date. That's a Thursday. And then every Thursday thereafter until paid. If you need more time, no problem. Call the court. We'll go on Zoom. I'll give you an extension. Okay? or you can walk in here on or before the due date at 8:30. Any questions?
No, it's fine.
All right, good luck. Thank you.
Thank you.
All right, are we ready on this? Donald James Kowalski, the fourth, 22T638-560. Your name?
Good morning, Your Honor. Michael A. Carmen, D73824, standing in for attorney record Dion Patillo.
All right. So Mr. Bologna left. He didn't know this case that the defendant was in custody. And now Mr. KB handled it. Is that correct?
Yes, and he was on the phone with Mr. Malone.
Your name, sir?
Donald James Kowalski, the fourth.
And this is going to be a plea to disorderly with the resistant obstructing officer to be dismissed, correct?
Yes, sir.
Is that what you want to do?
Yes, Your Honor.
If you plead to that, the possible penalties are up to 500 fines, 90 days jail, costs, or all of those. If you plead guilty, you're giving up the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving your right to remain silent. You're waiving your constitutional right to a jury trial. And you're waiving the presumption of innocence. And you're waiving the right to question their witnesses and to bring in your own witnesses. Also, you're waiving your right to use the subpoena powers of the court to bring in those witnesses. Do you understand that?
Yes, Your Honor.
If you plead guilty, we're not going to have a trial. Do you understand that?
Yes, Your Honor.
You still wish to plead guilty.
Yes, sir.
To the charge of disorderly conduct, how do you plead?
Guilty.
Were you in the city of Trenton on Fortner West on March 22 at 10:08 p.m.? And if so, what did you do that makes you guilty of this offense?
I didn't step out of the car as soon as the officer asked me to get out of the car.
So you refused the lawful command of an officer, correct?
Yes, Your Honor.
And he pulled you over for what offense? Did he tell you?
My girlfriend had gotten in a car accident and we had just totaled the car.
All right, I'll accept it. And are you on probation or parole right now?
No, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it. He's been in custody on this since. He already forfeited a bond on this back in 24 too. Anything else?
Your Honor, just ask for an immediate sentencing. Mr. Kowalski was sentenced by Your Honor on April 8th to 30 days for a similar charge out of Trenton. We're asking that you give him a similar jail sentence credit for time served.
Heather, do you have the case number on that one?
On the other one, let me get that for you, Judge. It is 21T 635872.
What kind of case is that?
It's a RHO.
And you said it's 21 what? C?
T is in Tom.
T121T 635872.
Correct.
Anything you want to tell me, sir?
Just that I apologize for my actions and I need to start listening and not. I just need to follow the rules when I'm told what to do. That's all I need to do. I apologize for that.
Life's a lot easier that way. 15 days jail credit, 15. I'll run it concurrent with the 21T635872. Case closed. Good luck.
Thank you, Your Honor.
I
You
hope
have a
you
great
grow
day.
up, though. Good luck. Thanks.
This courtroom session is a powerful example of how different legal strategies and personal decisions can lead to very different outcomes. We saw one defendant struggle to justify a no-contest plea, ultimately delaying their case, while others accepted responsibility and moved forward with guilty pleas, sometimes gaining reduced charges or deferred sentences. The judge consistently emphasized accountability, whether it was addressing substance abuse, reckless behavior, or failure to comply with the law. And perhaps most importantly, we saw how the legal system balances second chances with strict consequences, offering opportunities for rehabilitation, but never without conditions. At the end of the day, every decision made in that courtroom carries weight, not just legally, but personally. So what do you think? Were the judge's rulings fair across the board? Would you have handled any of these situations differently? If you found this case as intense and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.